seeking bribes for licenses, occupancy and other permissions. Does he have to bring this amendment, especially because his local bodies are infested with corrupt karyakartas? What is the problem? Please explain.
I think you have already covered this point when you spoke.
Because, sir,
Honorable Minister, let us move
Mr.
ahead.
Vijay Sardesai is using the word corruption. He is alleging there is corruption and trying to
let us move ahead.
I have not said a word on that. I am not even
No,
suggesting.
in your
I am only
objects,
suggesting
in your objects, you are
that
talking
I
of
am trying to
transparency and
improve a
efficiency.
system which is already existing by getting a good amendment.
I
That's
would
all.
suggest let us move
Why are you
ahead.
attributing motives to the
Okay, we'll put.
म्हणले मरे I am putting it to the vote of the house म्हणून आणि केन्ना राहून जातकर मागीर याद करता
Those in favor,
तुवें तें
please stand up. In favor of the bill, please stand up.
बीजेपी पंच करप्ट म्हणून उभे रावल्या तुम्ही
तूच म्हणटा मरे
हांव पंच करप्ट म्हणपा आहा
We'll move on. Those against, clause by clause. There are no amendments to the bill. The question is that clauses 2 to 5, clause 1, the enacting formula and the long title do stand part of the bill. Those in favor may say aye and those against may say no. The ayes have it. Clauses 2 to 5, clause 1, the enacting formula and the long title do stand part of the bill. The Minister for Panchayats may now move the bill for passing of the bill. May now move the motion, sorry.
Speaker, sir, I move that Bill number 7, the Goa Panchayati Raj Amendment Bill 2023 be passed.
The question is that the bill be passed. Those in favor may say aye and those against may say no. Ayes have it. The Goa Panchayat Raj Amendment Bill 2023 has been passed. Minister for Revenue may move the motion for consideration of the bill, the Goa Land Revenue Code Amendment Bill 2023.
Speaker, sir, I request to move that Bill number 9 of 2023, the Goa Land Revenue Code Amendment Bill 2023, to be taken into consideration.
The question is that the bill may be taken into consideration.
Speaker, sir, what is that? Yeah. Speaker, sir, considering the importance of stone crushers towards development of infrastructure in the state of Goa, in the past had issued an order number 14/11/2008 RD, dated 2/3/2009, thereby exempting the stone crushers retrospectively from obtaining conversion sanad. However, the above order was challenged before the Honorable High Court of Bombay in Goa in writ petition number 613/2009. The High Court, while order and judgment dated 17/11/2021, set aside the said order, stating that under Section 32, which is exempted in a class of land and not an activity. By the present amendment, considering the importance and useful contribution in infrastructure development of the state government wants to protect the stone crushers unit, which are operating with all valid permission registration obtained from the Directorate of Mines and Geology, Director of Industries, Trade and Commerce, as on 31/12/2007, and exempt them from provisions of Section 30 of the Land Revenue Code. Further, the state government will receive adequate revenue from the above activity. The Revenue Department will charge rupees 100 per square meter of such land per annum for a period of 10 years from the date of issuance of such registration, permission by the Director of Mines and Geology, Director of Industries, Trade and Commerce, and thereafter at the rate increased by 50% of the rate of land revenue last payable after every 10 years.
Yes, you know. Good ball.
Speaker sir,
Yes, sir.
the minister has said that there is a need to exempt crushers and basalt quarries for conversion fees. Now, and crusher licenses, does the government want to issue? What is the area that will be covered? What will be the finance implications on the state by waiving the conversion fees? I think the bill says that the finance implications are involved and they cannot be quantified. Why they can't be quantified? That's the question. Because the government must have received complaints or has some record of quarries and crushers without sanad. Someone must have come to the government asking to waive the sanad conversion fees for basalt crusher. Does the calculation of sanad conversion fees of these existing sites exist? If the government has no record, that means this is not a real issue, which means there is no need to bring the bill to the House. Speaker sir, my question is, how will the government know if the part of the land is agriculture or no development zone, or if there is encroachment on some neighboring land? The benefit of sanad conversion is that all these issues are brought on record. So if there is any illegality, the affected person can apply under RTI and check whether permissions have been taken. This bill is going to spell disaster for eco-sensitive areas, especially hills and plateaus. कोणूय खंय वता थंय खणपाक लागतलो in remote areas. Speaker sir, if people want to complain against any suspected illegal quarry or crusher, the panchayat and the collector are the first two departments which people approach. अशें धरया एक सांग्या क्वॉरी आहा इल्लिगॅलिटी करता जाल्यार ते मायन्स डिपार्टमेंटा कडेन पणजे येवचे नात, ते वतले पंचायती कडेन नाल्यार डेप्युटी कलेक्टरा कडेन. डेप्युटी कलेक्टरान स्टॉप वर्क ऑर्डर करूंक जाता इल्लिगल लँड कन्वर्जनाक. गव्हर्मेंट हें ऑप्शन कित्याक सिटिजना कडच्यान काडून घेवंक सोदता तें म्हाका दिसता मंत्र्यान मातशें एक्सप्लेन करूंक जाय.
फक्त हांव एकूच ॲड करता ताका, मागीर लेट रेव्हेन्यू मिनिस्टर स्पीक्स. 146 क्रशर युनिट्स आर प्रेझेंटली वर्किंग आनी ते बी 2007च्या पयलीं जे रजिस्टर्ड आसा 2007च्या पयलीं तांकां क्वॉरी मार्क करून दिल्ली आसा पळय न्ही, तांच्या खातीर मागता हे आनी 146 हे गोंयकार नाजाल्यार जातलें कितें परत तुमीच म्हणटाले तेंचे क्रशर बंद उडयले आनी आतां भायल्यान.
स्पीकर सर जे तुवें आतां उल्लेख केल्लो की तितून 140 गोंयकार आहाय म्हणून जे क्रशर युनिटाचे, तितून 140 तुला एकलोय मनीस आहा जो क्रशर हें चलयता गव्हर्मेंट लँडाचे ग्रॅब करून लँड ग्रॅबिंग, तुका खबर आहा तें. सो स्पीकर सर
हांव क्लॅरिफाय करता हो मुद्दो पयलीं क्लॅरिफाय करता. स्पीकर सर 2007 पयलीं ही लिजां दिल्ली गव्हर्मेंट लँडाचेर सुद्दां जर दिल्लें आसत जाल्यार 2007 पयलीं ताका दिलां ग्रॅब करूंक ना आनी ग्रॅब करूंक आमी कोणाक दिना आनी तेजी एरियाय बी ताका.
Speaker sir, this issue had come up last time as well in the last assembly. I just want to tell the Honourable Chief Minister, I will give it to you in person. The name, 3,510 square meters of government land has been grabbed. Anyway, Speaker sir, while speaking on this bill, I would request the Honourable Minister that he should suggest that the area, there's no mention of the area of such regularized cases must be specified as on date.
As per the lease.
I have got a list of areas basically in different talukas.
No, Honourable Minister in the object has said that he can't quantify the finance implications. Speaker sir, finance implication कशें येता? जमनीची एरिया आनी सनद फीज. आता जमनीची एरिया जर तुका खबर आहा जाल्यार सनद फी कॅल्क्युलेट कर मरे, इतले ऑफिसर बसल्या तुजे, मेळ्ळें तुका फायनान्स इम्प्लिकेशन. हय, तो प्रॉब्लेम हो जाता. फाल्यां आमचो इश्यू असो आहा की एक प्रायव्हेट जमनीचेर तूं खणपाक गेलो, हांव क्रशर ओनर पूण
नवीन आमी अलाव करिना हितूर म्हटलेलें आसा.
एक्झिस्टिंग इश्यूज आहा न्ही रे, ताणें सांगलें तुका एक.
न्ही पूण तेंय सांगलें तुका हांवें 2007च्या पयलीं जी लिजीस दिल्ली त्यांचोच विशय आसा हो.
2007ची सगळ्यो लिगल आहा.
2007 पयलीं ज्यो मायन्स डिपार्टमेंटान लिगल दिल्ल्यो त्यो आसा ह्यो.
तशें म्हणटा हांव, तातूंत भितर डिस्प्यूट ना.
एरिया एनमार्क्ड आसा.
ना
एरियन डिस्प्यूट ना.
गव्हर्मेंटाची जमनीचेर तिसरो करता अशें ना.
That is on working on water resources department land.
बसून घे.
ना स्पीकर सर तो सांगता पळय ते there is a particular land 3,510 square meters of water resources department.
येस. प्रश्न असो आसा विधेयक विचारांत घेवचें जांकां तें मान्य आसा आं बस सांगा न्ही उलया मरे तुम्ही उलया मरे तुम्ही उलयच
सर ते पण लिस्टाचे नाव आहे ते मातशे 4-5 नाव आहे
हां उलय उलय म्हणटी.
I'll just finish. Just a small this thing. While this amendment is said to be in respect of those quarries which are operating before 2007 or as on 2007, can you see the section 30, the first amendment, proviso? It says, provided further that nothing in this section shall apply to the activity undertaken in pursuance of the permission license granted under this MMRD Act and rules made thereunder. Now please see this, and then on the next page, 30A, that speaks of 31st December 2007. I'm showing you this for the contrast. Now please see how 30 looks. The words are like this. Nothing in this section shall apply to the activity undertaken. Where is the word undertaken? Previously. That means you can even undertake it now. Your intention I can understand, but the wordings which I will tell you, if I am to argue this matter and I'll tell you this undertaken previously is not, if I put the word previously, the whole effect, meaning change jata. Utar na zalyar, undertaking has an effect means, undertaken means you get the permission, you undertake it.
New permissions also can be given. Previously it is. This is previously.
Where is the word previously? That is where is it.
But
No, even the minister thinks it can be taken now. Minister or Sangta.
It is till 2007, 31st of December 2007.
That is different. That is condoning those. 30A is condoning, but this one is allowing new. Please look at 30.
Operating functioning is on the 31st day of December 2007.
No. Please look at 30. Section 2 amendment. Provided further that nothing in this section shall apply to the activity undertaken. Undertaken can be now undertaken also. Where is the word previously? You can add the word and do it. I have no problem. Otherwise, open jata.
Na, the data fix.
Date na.
Operating functioning as on 31st of December asa.
No. That explanation is only for 30A.
Experience. Boleh. Ha.
Ulo? Cruz asa bol.
Silva.
Section 30A is a standalone section. It's not subsection. Section 30A is standalone. Standalone section. So the explanation is to the standalone.
Speaker sir, हेजे लागू म्हाका दिसता ही बिल मातशें बेगीन दिवपा जाय आमकां 48 hours होवन तरी दिवपा जाय आसली लास्ट एक
We are helping the government. We are not opposing. Only the thing is,
if the government is not aware, Speaker sir, this is
a chance घेवन सगळे कोतले मागीर.
कोणाकूय चान्स पडटलो.
हे सिलेक्ट कमिटी धाडचे ना जाल्यार स्पीकर सर माहिती ना जाल्यार
उलय मरे.
Speaker sir, Goa Land Revenue Code amendment हांवें बरे भशेन वाचलां. आतां सांगलां ते भशेन मिस्टेक हें पास जालें जाल्यार आमकां खूब माल पडटलें आनी हें 1968 जाल्लें. तेच फाटल्यान जायते चीफ मिनिस्टर जाल्ले मिनिस्टराक कोणेंच एमेंडमेंट केलो ना. ताचो कॉन्सिक्वन्सीस कितें जावपा ते सगळे जाणात. आनी भोव करून हांव सांगता आमचे सांजे DRL मोर दॅन 100 क्रशर्स आहाय. आतां हांव नोका 140 दिला ते मोर दॅन 100 क्रशर्स आहाय. आनी सालजारा आनी सांजे DRL जरी तर आनीकय परमिशनां मेळ्ळी जाल्यार सांजे DRL आनी सालजारा गांव काबार जातलो. सो हांव मागता हें बील सेलेक्ट कमिटी घालचें आनी हे आमचेर घेश न्हू आनी हे फुडले कितें चेंजीस करून फुडले असेंब्ली सेशनां आमी घेवचें म्हणून.
जशें आयज सगळे MLAंनी ओपोज केल्लो आसा हे जो कायदो आसा आनी मिनिस्टरांनी सांगलेलें आसा की न्यू जी आसा तिवूय घेवपाक शकता. सो मिनिस्टरान मेन्शन केला. सो अशें जे डेंजरस बील आसा आयज तुमी पळयता आसतले एग्रीकल्चर लँड जावं खंय दोंगर आसा खंय खणपाक लागतले. फाल्यां
परमिशन फक्त मायन डिपार्टमेंट कोण कंट्रोल करतलो कारण पयलू कशें आसलें पयलू कलेक्टर कडेन पळोवपाक शकताले सो आतां समज हें बील कायदो हाडलो जाल्यार सगळी एग्रीकल्चर जो एग्रीकल्चर जमीन आसा कोणाक समज दिसते प्रायवेट प्रॉपर्टी आसा आनी ते प्रायवेट प्रॉपर्टीक आपल्याक खण करपाक जाय चिऱ्यांची खण करपाक जाय जावं आनी कितें खणपाक जाय मायनींग स्टार्ट करपाक जाय सो तो जाय तशी करूं शकतलो फक्त मायनींग डिपार्टमेंटाची परमिशन आसा हांगा कलेक्टर लँड यूज सगळो चेंज जातलो समज एग्रीकल्चर लँड आसा दोनूय सायडीन दोंगर आसा त्या दोंगरा मदीं एक दोंगर हाडलो आनी तो कट केलो नाल्यार सगळे सायडीचे जे दोंगर आसा तांकां सगळ्यांक प्रॉब्लेम जातली सो मागता आनी आमी अपोज करता एज अ ऑपोजिशन सगळे अपोज करता हो बील फाटी घेवचो म्हणून
हे दाखयता आसतना म्हणजे खूब मोठे कितें दाखयता परत एकदां सांगता म्हणजे पयले बील हे जे आहा पळय न्ही ते क्रशरा खातीर आसा क्रशराचो लँड युजा खातीर आसा ओके वीच इज क्लियर म्हणजे तितूर जे हय आनी इवन दो एक क्रशरा खातीर आसा सो दॅट एंड सेकंड जो यूज म्हटला पळय न्ही तेणी ओके इट इज टील 31 डिसेंबर 2007 हेज्या पयलींच्या युजांतलो आसा विशय तिको क्लियर आहा स्पीकर सर
नेक्स्ट वेंजी
आनी इवन दो अकॉर्डिंग टू द MMDR Act 2015 आतांय बी तशें पळोवंक वचत जाल्यार कन्वर्जन चार्जीस जे आसा MMDR एक्टाच्या अनुसार घेयना स्पीकर सर इन लीज एरिया
वेंजी वेगस
Okay, Speaker sir, I stand to oppose the government bill number 23, bill to make exemptions to conversion requirements under LRC. The bill proposes to make exemptions to the requirement to obtain conversion sanats for mining activities and for basalt stone crushers. The bill is unlawful because what we have brought in an amendment is 30A, an independent amendment 30. The requirements of section 30 are applicable to all activities and the exemption made for mining activities cannot be sustained. This will lead to unrestricted mining activities across the state, devastating the environment and the scarce of water resources of Goa. Second, the government has earlier tried to use Section 35 of LRC to allow stone crusher units to operate without conversion sanats, which was struck down by the High Court. The stone crusher units operating without conversion sanats across the state were to be stopped and demolished according to the High Court's orders. But government has protected the illegalities by not acting till date. The proposed amendment to allow stone crusher unit to operate without conversion sanats is completely illegal and is a blatant attempt to overcome High Court orders. And the law to aid illegal operators of crusher units who are destroying the environment. And my third point, the obvious inequality of the proposed exemptions for mining and crusher units is that poor, ordinary citizens, schools, hospitals and other socially important activities will be required to obtain conversion sanats even for their small requirements, while profit-making corporates will be given an exemption for the most destructive and unsustainable activity in the state. I would like to put this on the floor of the House. I would demand for a select committee and for a division of votes on this bill number 9, sir.
Speaker, sir, 30A जो आहा पळय न्ही land use in relation with a certain basalt stone crusher unit हो म्हाका दिसता क्लियर कट वाचचो तो क्लियर कट वाचीत जाल्यार तें बिल क्लियर जाता स्पीकर सर हातूर क्लियर एक्सप्लेन केल्लें आसा बिफोर 2007 चोय विशय क्लियर केला आनी ताज्या उपरांतचोय जो विशय आहा पळय न्ही तितूरय क्लियर केला एप्रॉक्सिमेटली स्पीकर सर हातूंत जाय जाल्यार इट इज एन notwithstanding any constraining the code or any other law or the time being in force or any in contract judgment, decree or the order of any court of the law in any instrument and having the force of law, not by the section 30 shall be applied and to the land use for the operational functioning to the basalt stone crusher unit and which was operating functioning on 31st day of December 2007 in pursuance of the valid permissions registration obtained from Director of Mines and Geology, Directorate of Industries, Trade and Commerce, and such basalt stone crushers unit shall be deemed to have been lawfully using such land for carrying on the operation on the basalt stone crushing subject to the condition of such basalt stone crushers unit pay to the government land revenue at the rate of rupees 100 per square meter of such land per annum for the period of 10 years from the date of the issuance and of such registration permission by the Director of Mines and Geology, Director of Industry, State of Commerce, and thereafter at the rate of increase by 50% of the rate of the land revenue last payable after every 10 years. Clear as a speaker, sir.
I just want to help the government, because I'm telling you what will happen is there will be applications which will ask you now for this, and they will use this clause. I'm going to show you why. Please look at your own bill. When you see clause 3, clause 2, insertion of new section 30A. Can you see that? Insertion of new section. After section 30A, the principle, the following section shall be inserted. Now please look down. Explanation. For the purpose of this section, that means these words which you have explained, 31st December 2007, applies only for this section, which is 30A. It does not apply for the above one, proviso. That proviso will be opening the floodgates for anybody to get the benefit. That is what it is. So now that is it. You're saying yes, you're saying no. Which? Soglan Yupache? Just now the Honorable Chief Minister said no, it's 2007.
Section 30 is applicable for everyone, and you're introducing 30A.
30 Soglan
select committee घालया आणि परत रिवाइज करूया जे चर्चा करूया select committee घालून सध्या होल्डार दवरया and if there is a majority it is bad in bad in law.
एक मिनट ऐकून घ्या.
Law Minister, Speaker sir, the bill has been written by the Law Ministry, and I will explain to you what it is a law subject. I will explain to you what it is, Speaker sir. Speaker sir, हे जे 330A जो आमचो advocate Carlos Bab सांगता it is specific for exemption for that particular period which is mentioned and explanation has been given. By itself, all mining under MMDR Act, even major minerals which are there, this is minor minerals. Under MMDR Act, everybody is exempted from surface right conversion, which is already, let me explain. This is what is being brought in this. This is already there.
With great respect, don't confuse surface rights under MMDR Act.
Not surface right, for conversion.
If it's already covered, then you don't require this.
That is what is brought.
You are making
it is under this Act, which is Act, MMDR Act, which is there. You read it, sir. Speaker, sir, provided a further noting that in section shall be provided to activity undertaken in pursuance. The major Act of 30 allows you to do it. So clarification of 30A is to bring it into existence for those people.
No mining, major or minor can be undertaken without license under MMRD Act.
Yeah, so MMDR after license only it is given.
Then you require conversion, Sanad.
No, Speaker, sir.
So you are removing
sir,
this.
Issue how, Speaker,
understand.
Sir. Amendment to Section 30. In Section 30 of the Goa Land Revenue Code 1968, Act number 9 of the 1960, hereby referred to as the Principal Act. After existing provision, the following provision shall be inserted, namely, in the major act itself, we are bringing the provision in 30. Provided further that nothing in this section shall apply to the activities undertaken in pursuance of the permission/license granted under the Mines and Mineral Development and Regulation Act 1957, Central Act of 1967 or 1950 under rules on that matter. Therefore, so we are in this section. We are bringing the main section itself that everybody is exempted. In 30A, we are bringing this provision because there was an issue on the High Court where they are also covered, Speaker, sir.
See, what is happening? What is happening is for those of 2007, you are punishing them by giving them this such amount. And for those of now who will undertake, where is that 10 years and all that to be paid? This is only for those who have done before. 30A is to legalize those which were functioning illegally. Now, what about this 30? What will they pay? You are exempting them and they'll pay nothing.
Speaker, sir, because there was no clarity, that is why 30A is being brought. And 30A, that proviso is being made, which is very clear. As far as 38, what he says is that exemption which is made is for those people who have met in the High Court. And that is why this provision has been made for 30A. Yes, is added to that, Speaker, sir. What you are saying is correct.
There is no objection to that one. No objection to 30A. But my question is 30, the proviso will go across the board and give them a free run.
Speaker, sir, this is the Act. And if what he is saying, then the rules will be brought afterwards. Whatever he is saying, we will bring the rules for them.
Yes.
No, there is no reason for select committee.
Next
Very clear, Speaker.
Pass करून rules हाडपाक Speaker, sir.
we
rules and पळयता. We'll see in the rules.
Yes.
He is only saying it is going to be brought up, so bring it under select committee. Why is the hurry to pass it out now?
Yes.
You are going to put complications.
Whatever rules
This is
have
going
been
to make
framed,
people suffer.
the rules will be
You need
framed
to amend
independently.
section 30 rather than introducing 30A. You 30 amend करपाक आशिल्लें,
प्रश्न
तितूय add करपाक जालो
विधेयक
paragraph.
विचारान घेवचें
No, that 30 would have been a
जाका
separate.
मान्य आसा ताणें हय म्हणचें
Speaker, sir, I request
जाका
to
मान्य
move
ना
that.
ताणें ना म्हणचें हय म्हणटाचें म्हणणें मान्य जालें हय
But
म्हणटाचें म्हणणें मान्य
हे
जालें
totally wrong.
एक विचारान
Because हे
घेवपाचो
तुकाय
प्रस्ताव
सारकें न्ही.
मान्य जाला
गोंयकारा पासत ते तुकाय सारकें
हांव
न्ही. सिलेक्ट
आतां
कमिटी
विधेयक कलमवार सभागृहांत सादर करता विधेयकाक दुरुस्त्यो नात प्रस्न असो आसा कलम 2 कलम 1 अधिनियम सूत्र आनी प्रदीर्घ मथळ्याचो विधेयकाचो भाग जावचो काय कितें जेका मान्य आसा ताणें हय म्हणचें जेका मान्य ना ताणें ना म्हणचें हय म्हणटाचें म्हणणें मान्य जाला हय म्हणटाचें म्हणणें मान्य जाला कलम 2 कलम 1 नियमन सूत्र आनी प्रदीर्घ मथळ्याचो विधेयकाचो भाग जाल्यात महसूल मंत्री आतां विधेयक मानून घेवपाचो प्रस्ताव मांडचो
Sir, I request to move that Bill number 9, 2023, the Goa Land Revenue Code Amendment Bill 2023 be passed.
प्रश्न असो आसा विधेयक मानून घेवचें जेका मान्य आसा ताणें हय म्हणचें जेका मान्य ना ताणें ना म्हणचें
We had asked for a division of vote. अजून तुम्ही division of vote गेल ना. We had asked for a demanded for a division of vote.
Yes.
Why do we have to repeat?
हय म्हणटलें हय म्हणटलें उबी रावत स्टँड अप
Those are in favor.
Asani pura. Asani pura.
जालें
मेज तू कितले जाता
27 अच्छा ना म्हणटलें उबी रावत स्टँड अप 1 2 3 4 5 6 7 7 हय म्हणटाचें 27 ना म्हणटाचें 7 येस हय मिनिस्टर हय म्हणटाचें म्हणणें मान्य जाला हय म्हणटाचें म्हणणें मान्य जाला गोंय विधिनियम वसूल कायदो विधेयक 2023 मान्य जाला भारतीय स्टॅम्प गोवा दुरुस्ती विधेयक 2023 रेव्हेन्यू मिनिस्टर
Speaker, sir, I request to move that Bill number 10 of 2023, the Indian Stamp Goa Amendment Bill 2023 be taken into consideration.
येस प्रश्न असो आसा विधेयक विचारान घेवचें जेका मान्य आसा ताणें हय म्हणचें जेका मान्य ना ताणें ना म्हणचें
Speaker, sir.
हय म्हणटाचें म्हणणें मान्य जाला
Speaker, sir.
येस ओके
This bill seeks to amend clause A of Article 32 of Schedule 1A to the Indian Stamp Act 1899, in bracket 2 of 1898, as in force in the state of Goa, so as to give benefit to of reduction in stamp duty leviable on instrument of gift executed in favor of brother-in-law or sister-in-law as well, and to encourage registration of more such instrument. This bill seeks to achieve this above objective.
येस उलय
Current Stamp Duty Act allows a person to gift to father, mother, brother, sister, wife, husband, daughter, son, grandson and granddaughter. Pairing the wife, which is a legal relation to the gift, rest are all blood relations. This amendment that the minister wants to bring is adding brother-in-law and sister-in-law, very specific. Now, which brother-in-law and sister-in-law has approached the government to bring this specific amendment? Because, sir, no, 1 minute, don't disturb me. I'm on my feet. Because, sir, अशी बिलां जी हाडटात ताजेर एक डावट येता की बाबा हे इतलें कितें ब्रदर इन लॉ म्हणटकच आतां आय एम जस्ट एक्सप्लेनिंग नाव. Speaker, sir, brother-in-law is not a blood relation. Brother-in-law can mean wife's brother or sister's husband. Which one is the bill referring to? Both. Okay. Now, if it is sister's husband, then there is no use of making a gift deed. Because if you gift your sister, her husband will get her half share automatically. If you gift to your sister's husband, your sister will get the half share. So why bring the bill? One minute. Problem with gifting to your spouse's brother or sister is what will happen if you divorce your spouse. Gift दिला मागीर तुवें divorce केली मागीर कितें करता तूं? one minute. सांगता मर तुका. What will she remain your sister-in-law or will he remain your brother-in-law? Will the gift remain valid? No, will the gift still remain valid? Speaker sir, these are matters of law. One should be able to gift assets to their daughters-in-law and sons-in-laws also. Why only brother-in-law and sister-in-law? Give to daughter-in-law and son-in-law also. And if brother-in-law and sister-in-law are added, why not nieces and nephews? I'll give you an example. An unmarried individual treats his nephew or niece as their own children. So why this relation should not be added? I'm unmarried. Mazo baso to mazo cholo ata. Ashi jata if I am unmarried. Speaker sir, ani ek practical issue जावंक शकता. अशें धरया की there is a couple without children and they are living in the husband's house as joint family. Speaker sir, हे आयकुचें हा मातशें. Seriously, मुखेलमंत्र्यान आयकुचें. असली बिलां हाडटा म्हूण. एक couple हा living in the husband's house as joint family. Husband dies and wife, who is a housewife with no income, has to stay with the mother-in-law and brother-in-law. There is no law protecting the right of the wife since husband's share goes back to the husband's family. This is the case in point today in the law. The in-laws can easily put her out of the house. ती विधवा झाली, ती उरली आता. I'm just telling you, listen man, don't talk first and I'm talking